All right. Anthony Rico, is that what I got next?
Let me go grab him, Judge. We had to remove him. It'll be one moment.
There's always one. All right, Anthony Rico, a criminal trespass. All right. All right. Mr. Rico. Are you Mr. Rico?
Yes, sir.
Good afternoon. My name is Walt Weaver. I'm the judge of Potter County Court of Law number 1. I'm going to be hearing your case today. I've reviewed your plea papers, Mr. Rico. It appears to me you're ready to waive all your constitutional rights in exchange for a plea bargain agreement. But you do have an absolute constitutional right to appear in my open courtroom and face your accusers. Or you could also choose not to use that right as well and agree to appear by video. Are you agreeing to appear by video?
Hey, if I can, man, you can just like figure it out in court and I guess.
Guys, today we're diving into a courtroom showdown filled with tension, strategy, and shocking moments. In this first scene, the tone is set as the attorneys step in, papers shuffle, and the judge takes control. You can already feel the weight of what's about to unfold, with both sides bracing for a heated legal battle.
Are you saying you don't want to do this on video?
I'm not trying to be in court hearing and doing stuff on you. I just ain't got
Mr.
time.
Rico, it's real simple.
I don't got time to be here, man. If you can, just do your job or do whatever you're doing or something, man. But I don't really care what you do, man.
I'd love to do my job, but part of my
It's
job
not my
is
job,
making
dog.
sure
It's not my fucking job, all right? I don't give a fuck what you look like. You know what I'm saying? Your job is gay.
I'm going to hold you in contempt.
Hey, bro, I don't give a
fine.
fuck what you talking about,
Remove the
man. All right?
individual.
Don't give a fuck what you talking about, man.
Bye.
Super. Get a job. Be a street girl. He's better.
Do we need to preserve this as evidence now since that's resisting? All right, don't delete the YouTube video. That's unfortunate. Hey, Ethan. Keep them coming, man.
I apologize, Your Honor.
Oh, it's not your fault. That's part of our part and parcel. Boy, he's so little, and look how much people he's got. Could you please put him, Miss Morris, on a transport next time so we can get it done? Boy, if that's not the funnest name I've said all day. Man, it's too bad Mr. Rico could have gone home today. He decided he'd rather stay.
You might have got a new prosecutor today.
Well, it's all live. You saw him fight the deputy. Technically, he's under arrest in a jail. Do you have to prove that element?
Hello, sir.
Good morning, Your Honor.
Good morning. Can I have you state your name and date of birth, please, for the record?
Mark Briggs, 10/3/19.
Here, the attorneys waste no time cutting to the heart of the dispute. The questioning is sharp, and every response feels like it's building toward a bigger revelation. The courtroom energy shifts as small details hint at larger conflicts. The kind of moments that make you wonder if a game-changing statement is coming next.
1964.
Mr. Briggs, you're before the court today making first appearance, Raymond, on 2 charges. The first is malicious mischief in the 3rd degree. It's a gross misdemeanor subject to 364 days in jail and a $5,000 fine. Second is harassment, domestic violence. That's also a gross misdemeanor, subject to 364 days in jail and a $5,000 fine. Because the charges have domestic violence enhancements, they are something where if you're convicted of them, it would result in your inability to possess firearms.
I don't own a firearm. That's
okay.
what I told
Again,
you.
I have to let everybody know whether you have guns or not. Because these are criminal charges, sir, you have several important rights today, including the right to remain silent, the right to a speedy and public trial, and the right to an attorney. Would you like to be screened today, sir, for a court-appointed attorney?
No, sir. I'll be getting mine.
Okay, sounds good. So enter a not guilty plea today.
Yes, I do have something I want to add, though. I was denied due process.
You have an attorney. We're going to hire an attorney. Your attorney would probably have you exercise at this point your right to remain silent.
I don't want to exercise my right to remain
Because, Your
silent
Honor,
because I have
good
nothing
record.
to hide. So I was denied due process. I have paperwork that proves that I owned the car before I was married. So therefore the car is mine. And no, since we're in separation, No judge has divided property yet. So technically the car is still mine. So I wrote on my own car. That's a fact. Here's the paperwork. I
We're
sit
not
down at
having
the
a
bank.
trial today.
Well-
We're having your arraignment.
Okay.
You're entering a not guilty plea.
I was denied
You've
due
told-
process,
hold on,
sir.
Hold on.
You said I could
You've told,
speak.
no, I
didn't want
didn't.
to
I said you should exercise your right to remain
I choose
silent.
not to, sir.
Your attorney, if they were sitting there, would not have you making factual statements on the record.
That's my discretion, sir. Because I believe there's Fourth Amendment charges. I was denied all kinds of rights, and I will be.
Key witness is pressed for clarity, and the tension rises. The back and forth is quick and calculated, revealing cracks in the testimony. You can see the attorneys pushing hard to either break credibility or strengthen it, and the judge's careful attention signals just how critical this moment is to the case.
Coming back with a vengeance. I have
Are you
paperwork.
threatening the court?
I am
sir?
not threatening the court anything. I'm not threatening anybody.
You just-
I have the
you
right
said
to
you were
sue.
coming
I have
back
the
with
right.
a
I have the
vengeance.
right to sue this city, and that's what I just said. So if you want to take that farther than that, that's up to you. I did not say that. I'm
You
making
said
it
you are
clear.
coming back with a vengeance.
With an attorney.
On
It
the
doesn't have
record,
anything to do
yeah.
with me. That's not a threat to you. The city. I said I'm suing the city. So you do what you want today. Go ahead and hold me in contempt. Go ahead. I'm suing the city. I will be suing the city. If you will take that as a threat, then that's fine. I will be talking to the city attorney. I've already talked to the city. I'm talking to people. I talked to the police chief already.
Yeah, I've seen how you've conducted yourself. so
Yeah,
far.
that's right. Because I'm being wronged. It's my house. She had no business being there, and she hasn't even lived there for 6 months. She hasn't paid a bill for 8 months. She can't just come there. I have rights.
You do?
Just because she's entitled to
So
be
again,
able to be on the
we've
property
talked
doesn't mean
about-
she can just
We've
come.
discussed your rights today. We're not going to litigate your case today.
Do I have the option to
This is-
speak with the city attorney
This
as
is
well?
a criminal court.
Do I have the option to speak with the city
Not once
attorney?
you say you're going to be hiring an attorney.
Do I have the option to speak with the city attorney? I'm not hiring an
Not
attorney.
today.
I want to speak with the city attorney.
Would you like to be screened today, sir, for a court-appointed attorney?
No, sir. I'll be getting mine.
Not today.
Okay. When would I be able to do that?
That's me, sir, and I will give you my card.
Okay.
But we do have some release conditions we will be requesting.
Okay. Go ahead, Ms. Carmen.
Yes, Your Honor. We are requesting a formal no contact.
The questioning turns pointed, touching on sensitive timelines. Each answer feels like a piece of a puzzle, with the attorney trying to connect them into a narrative that works in their favor. The witness's tone shifts, suggesting a mix of defensiveness and uncertainty, which keeps the tension thick in the room.
Contact order with victim notification.
It should have been me filing.
Hold.
She's
Please,
harassed
sir.
me.
Please, sir,
All right, go ahead.
the facts of this case are highly concerning with regard to the threats that were made. These folks are in the midst of a dissolution. Statistically, through peer-reviewed literature, that is one of the highest risk times for partners who are splitting for domestic
Well, what about the
violence.
time I got punched in the chest 5 times? Nobody did anything about that, and I reported it to the officer. Upon arrest, I told him 2.5 months ago, I've been punched in the chest. I will take a lie detector test for that and pay for it. And I received
Point,
nothing.
the city attorney's making her release recommendation. You need to let her finish.
I was denied due process. You guys didn't take my complaint. So you didn't even take my complaint. And then you don't want me to call it racism. You didn't even take my complaint.
The only thing we are doing today, sir, is you have entered a not
Well, there
guilty
should be
plea.
equal treatment under the law, and I have not
We're not
received it.
litigating your case today. I've already told you that. You've seen every other person come up here. I've entered not guilty pleas. I've set
Well, I
release
want to put this
conditions.
in the record.
Please
Can I
sign.
give this to the attorney so she can follow up on this? This is my proof that the car is mine. There's been no dissolution. No court has divided property.
So would you like me to continue?
Yeah.
So again, we are asking for the victim notification. There was an ex parte no contact order approved in Clark County Superior Court this week. However, As of yesterday, it had not been served, so there is not formally protection in place for the victim.
I don't go to her. I am at my house. She came to me. I never go to her. So why is the order against me when I don't even deal with her?
Please let the city attorney finish her recommendation. So we're walking on a very fine line right here with your conduct in court today.
Okay, I'll stop. Sorry.
Thank you. Go ahead, Ms. Carmi.
So yes, Your Honor, and while there's no in-state prior history with domestic violence, there is a older mid-1990s arrest.
We hit one of the day's more intense exchanges. The lawyer's voice is firm, the witness hesitates, and the courtroom falls into an uneasy silence between responses. Every pause feels loaded, and the judge's interjections keep the pace tight, making it clear this part could tip the momentum for one side.
Reversal for so there is some history there. We think all of the circumstances in this case, particularly with regard to statements of harm to the victim at this time, warrant that victim notification.
I don't even go to Oregon, sir.
I will
She lives in
add,
Oregon.
I will add, because Mr. Briggs has brought it up, we are not seeking to remove him from the home that he is residing in.
How you gonna? She don't even live there. Are you kidding me? She doesn't live there. I paid the mortgage there for the last for 4 years. I paid the mortgage, and I can prove that.
Mr. Briggs.
I'm trying. You're gonna remove me from my home? What are you talking about?
She's saying she is not.
Why are you even saying that?
Because
She don't live there. Her address is in Oregon. Why are you even saying that?
I will add, because Mr. Briggs has brought it up, we are not seeking to remove him from the home that he is residing in.
How you gonna? She don't even live there. Are you kidding me?
Your Honor, the reason that I'm bringing this up is that the victim has requested a civil standby so that she can go get her personal belongings from the home.
Property has not been divided by the court. She has her personal items and her personal belongings. And then the court has to divide the property. That's what I've been waiting for. I've encouraged her to file the divorce papers, sir.
I will be finished here shortly, Your Honor. The proposed NCO that we have drafted after contacting Battleground to make sure this is something that they could do.
That's against the law. No way.
Is that she can call for a civil standby where they would go to Mr. Briggs' home. She has the same 15
She
to
can't
20.
come there and just take whatever she wants out of the home. It hasn't been divided by the
This section brings a crucial discussion about past agreements. The attorney zeroes in, trying to lock the witness into a specific version of events. You can sense both strategy and risk here. One wrong word could either cement the argument or unravel it completely in front of everyone present.
divorce court. I don't have a problem sharing, but it's an argument every time.
So one of the things that you've brought up, Mr. Briggs, today is that there was likely separate property, it sounds like, prior to your matrimony.
Yes, sir.
My assumption, and I could be wrong, my assumption is that the other party also had separate property prior to the matrimony. So yes, you are right. The court, if the property is shared property, the court certainly cannot order a person to go in and take shared property. You are correct on that. The court, however, can, if there is separate property of hers in the residence, allow her to retrieve separate property.
But she's taken my property. That's the reason why I don't want her
I
in the
don't know what
house.
she's going to do. We're talking about prospectively, sir, not retroactively. When she shows up at your home and takes her separate property, that would be allowed. Do you understand?
That's actually not allowed because
Yes, it
I
is
still,
allowed.
no, it's not. No, it's not. No, it is not. She can't just come there and take stuff. Now,
You
she
can
could
take
have
things
asked
that
for
were
it.
separate property of hers.
She does have her
prior
property. The
to
only thing is,
holding-
sir, she didn't even have any place to put the stuff. She's in a bedroom at her mom's. Now, she can have the kitchen table, which is hers. I don't have a problem with that. I've held nothing from her. I don't want to fight. The reason why we have not been around each other is because of what happened the other day. I didn't want that to happen. I've made many statements to family and relatives that I refuse to be around her. I believe she's demonically possessed by the Jezebel spirit. So I don't want her around me. There's a visceral reaction that I haven't felt around a person in many years. If I'm from here to her, I want to throw up. I literally cannot be around her. And I've required that she not come to the house. She came to the house.
The focus shifts to document evidence, and every page seems to carry weight. The witness is visibly cautious, answering in a way that avoids absolute commitments. The lawyer's persistence shows they believe these documents might hold the leverage they've been waiting for.
Because I refused to get the HELOC with her to help her pay off her bills. So she came to the house the next day, and then that's when everything started. I was sitting there with my brother-in-law, drinking beer by myself, like I always do. I didn't go to her. She came to my house. And she has forfeited, I haven't proved it, but she's forfeited her right to the property. She hasn't paid a single bill there in 8 months. And when she left, the moment that she took her and got a new bank account at Columbia Credit Union, that's the day of separation. That was over 8 months ago. She cannot just come to that property. She cannot.
So, Your Honor, I have, if you do adopt it, change the language in the civil standby to indicate that the law enforcement agency would assist the protected party in obtaining personal belongings.
She has her personal belongings, and not only that, she stole every picture off the wall, which she was not entitled to. She stole all of our financial records, which she was not entitled to all of it. So now I'm in a position when I do go to court to battle her, all the financial records are in her possession because she stole them out of the house. But when I got arrested, they wouldn't even let me go and secure my home or give them any instructions on what to do with the property. I said, don't let her in there. I got silver. She's going to steal it. And she went right in there and started taking everything off the wall. She left me 2 tablespoons and 4 teaspoons. She knows I love tablespoons. So everything she did was to spite me. I have gone out of my way to stay away from her. You can interview any one of my neighbors.
The court only establishes this court. This is a criminal court that you're in.
And that's what I'm saying. You don't have the right to divide property in a criminal court. We haven't gone to court yet. You don't have jurisdiction to divide property.
I have jurisdiction for a victim to be able to retrieve property.
What would I be keeping from her, sir? She has all of her clothing. There's a table and a side table in the bedroom. That's all that's there, and whatever's in the garage. I haven't kept her from anything. I'm trying not to kill her.
We get into a timeline dispute, and it's clear both sides have very different recollections. This is where cases often turn as precision matters. The attorney works methodically, almost like dismantling a clock, piece by piece, to show the inconsistencies in the other side's version of events.
She's come to me.
Okay, so, Your Honor.
Okay.
That's not.
I'm
Now, hold on.
I did actually ask he be held on $10,000 bail.
Listen, sir. Listen.
You can't.
I'm not saying it like that. I'm saying that I've tried to keep her away because of violence. I don't want.
Very much keeping with statements.
Oh
that
my
were
God.
made
Do you
after
understand? Does anybody
Yeah,
understand?
take
I
him into
didn't
custody.
never touch her.
Officers, take him into custody.
I never touched her. I didn't want to harm her. That's what I've been doing the whole time. Man, I'm getting crunk down here, and it's gonna be on. This is prejudice and
Okay, I'd like-
racist as hell.
I'd like no bail.
You're racist.
Well,
I have
he
not
just
done
threatened-
anything to her.
He just threatened to get crunk on the court.
So what? What is that? So you're taking away my freedom of speech? I can't express myself now?
Can't threaten.
I haven't committed any crime. I haven't touched anybody.
All right. So
I don't want her at the house. That's what I've tried to avoid.
at this stage, we're gonna set Mr.
Ain't never,
Briggs.
because she punched me in the chest. I'm prosecuting her, so you take that. I want to see somebody about that right
We're gonna
now.
set Mr. Briggs.
And I'm pressing charges on her.
Out 1 week.
She punched me 5 times, and I will take a lie detector and pay for it.
We're gonna
Can I
set
speak to
Mr.
somebody
Briggs
and press
over to
charges
the
on her?
12th of December,
You
2024
know what I'm saying?
at
Hey, you know
8:30
what? My
a.m.
shoulder, I'm in, yeah, we're not.
The release conditions in place are to violate no laws, appear at all mandatory court dates, to notify the court of any change of address or phone number. I'm signing off on a standalone no contact order.
So I said I didn't want to kill her, and I've never threatened to kill her. I'm just expressing to you that I don't want any bodily harm towards her, and you're arresting me for that. And it's a freedom of speech. I didn't touch her. I've never put a hand on her. She punched me. Can I press charges? Can I see someone to press charges on her right now?
The questioning sharpens again, pressing the witness into corners. Each clarification requested feels like a trap carefully laid out. The witness pushes back, but the subtle tension in their voice suggests they're feeling the pressure, and the audience can almost sense a breakthrough.
Your Honor? Your Honor?
This is your arraignment today, sir, on criminal charges. You've made a number of threats on a recorded
I
record.
didn't make any threats to anybody.
Well, we'll listen
How is
back.
that a threat? Freedom of speech. I didn't threaten anybody. I didn't say I'm gonna kill her. I said I don't want to.
Sure, we'll listen to what they say on the records. You're being recorded. I told you to remain silent.
Well,
Your choice.
I knew you was gonna do this. I knew you was gonna wait till I slipped and then you was gonna throw me in jail, and that's fine. Because I'm coming with Trump. That's not a threat. That's my personal lawyer that I'm gonna get to fight you guys
When
with.
people threaten killing someone on the record, sir, I take
I
that
didn't threaten to
extremely
kill her.
seriously.
That was not a threat to kill her. I didn't say I'm going to kill her.
We're recording.
I said I don't want to. And
That's
that wasn't
fine.
even, that was just a figure of speech.
It's recorded.
I don't care if it's recorded.
We're on intensive pretrial release. At this time, I'm going to impose bail in the amount of $25,000.
And then, Your Honor, if it is posted, could we have the victim notification?
Victim
requirement?
notification will be put in place.
Thank you.
This is a railroad, man. I'm telling you.
All right, thank you, sir.
All witness this, that's bullcrap. He came to my house. Jesus Christ is my Lord and Savior, you devils. You're all devils.
We're now at a stage where the stakes feel higher. The attorney raises points that tie back to earlier testimony, creating a web of connections. The goal is clear: build a chain strong enough to sway the judge's perception and, by extension, the outcome of the hearing. Here, the witness is asked to clarify past actions under oath. The attorney's tone suggests they believe a contradiction is about to surface. Every word is weighed, every pause analyzed, and you can almost feel the judge mentally filing away each statement for later consideration. The final moments are a mix of exhaustion and determination. The last exchanges hint that while answers were given, not all questions found resolution. It's a reminder that in court, sometimes the real battle happens in the subtle gaps between words. Thanks for watching. Don't forget to like this video, subscribe to the channel, and we'll see you in the next one.